Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Hey, welcome back. Today, I'm excited to have join us on the show, Sud Patel. Sud, how you doing, man?
I'm doing great. Thanks for having me.
No, I really appreciate you agreeing to do this. And, for anybody listening who doesn't know Sud, he's a fixture on the PAJ circuit, a past president of the Pennsylvania Association of Justice, which is a major feather in any attorney's cap, and big law pack fundraiser. I think you must stick more to the East Coast side because I haven't had you hit me up. It's all the East Coast guys or the West Coast guys that are always hitting me and Greg up for the law pack contributions. But we need attorneys like you to do that, for the benefit of all of us and our clients. And then I saw you were the past president of the Schuylkill Bar Association at some point in time. So all these high positions. So thanks for being here today, Sud. And aside from my kind of lame tee up of your background, can you tell us a little bit about yourself and what led you into the path of trial lawyer work?
Sure. So this is year 30 for me as a trial lawyer, and proudly all 30 years have been on the good side of the V, representing injured victims. The story of how I got into this is a little bit interesting. My parents are both immigrants from India by way of West Germany. My dad came over in 1970 along with my mom. I was 6 months old, and he was in the steel and titanium business and had a partner. So right around 1987, 1988, he and his partner started having a lot of disagreements over running the company. In 75, my dad was a little short on money when my sister was born, and so his partner, quote unquote, lent him some money with the idea that my dad would give him 10% of the stock of the company, going from 50-50 to 60-40. My dad pays the loan back and the shares are supposed to be restored. That never happened. Fast forward to 1987, I'm a junior in high school getting ready to apply for college. They have a big disagreement, and my dad's partner basically locks him out of the company. At the time, I'm working at our local golf club, and I find out from my parents that dad's has some sort of business issue and he's looking for lawyers. Goes to several in Schuylkill County. None of them want to touch my dad's case. And my dad finally, one night is at home and is really worried and pouring his heart out about what happened. And, the little I understood. And I said, look, why don't you call these guys? I see them at the golf course and they're always really nice guys and they drive nice cars and they're pretty good. And that led to a phone call from my dad to Jim Riley and Fred Fanelli, who ended up becoming not only my mentors, but my first employers right out of law school. And I've been here ever since. So this is really the only grown-up job I've had. So they ended up representing my dad in a minority shareholder oppression suit, which lasts about 2 years. And when the writing was on the wall that my dad's partner had no leg to stand on, they finally ended up settling it. My dad was restored and made whole. And that's kind of how I got introduced to the world of what trial lawyers do. Being the kid of immigrants, I wasn't allowed to go to the Jersey Shore and spend the summers lifeguarding or screwing around like a lot of my friends. I had to do all kinds of jobs around the house and in the community. And, it was a working deal. So when the litigation starts, my dad would literally drag me to the meetings he had with Jim Riley and more so Fred Fanelli. And that's how I get to know those guys and hang out and watch what they do. Started my freshman year of college and they were nice enough to say, look, you're a nice kid. If you have any interest in the law, you can come back and do some odd jobs around the firm. So I literally started in the firm when I was a freshman in college, every summer, every Christmas break, and then never really put a resume together. I think the first resume that I put together was when PAJ asked me for something as I started getting into leadership. So that's kind of the story of how I landed. And although I'm not born and raised in Schuylkill County, I've been here a long time.
Before you had this kind of turn of events that pushed you into recommending and then working with trial lawyers, were your parents, whether it was gently or forcefully encouraging you to go into different lines of employment in the future?
Oh, without a doubt. So, my undergrad, I went to Lehigh University in Bethlehem, known as an engineering school. And I thought I'd just get an engineering degree and work with my dad. That was the plan. In my dad's eyes, again, being an immigrant, you were a doctor, a lawyer, an engineer, or it just didn't matter. So I get to Lehigh my freshman year. I've got 19 credit hours, engineering, calc, physics, chemistry, and I'm just scratching my head thinking, I don't really want to do this. So I go down to the registrar's office and switch out of the engineering school into the business school. Didn't tell my dad for about 90 days, and he blew a gasket and really didn't forgive me until I got accepted to law school at Villanova. And then finally he got over it, and then the rest worked out, fortunately.
Yeah, I was going to say, all of my, second generation immigrant friends growing up, it was their parents. The dictate was doctor, then engineer, and then really nothing else. I mean, lawyer, even after it was a distant third, as far as that's concerned. So I can only imagine, the getting used to the adjustment that your dad had to make to you going the path of law. But it seemed like kind of destiny, and amazing how it worked from you recommending these attorneys that you met at the golf course to then now you became partners in that law firm years later. Amazing story.
Yeah, it's been a great ride. But again, a lot of it, obviously great parenting, and I've been fortunate. But I had some great mentors, Fred Fanelli in particular. When I started working with and for Fred, I finished college a semester early. So instead of just being at Lehigh and having a good time, I ended up coming back. I'd be at home usually Monday through Friday afternoon working at the firm. And then I'd go down for what would have been my last semester of college and spend the weekends with my buddies, having fun and then coming back. So he was great. I glued myself to his hip, and everything from trials to client prep to municipal meetings. I got a great experience. So, between great parenting and great mentoring, I've been really lucky. And I just said to my younger partners, Brendan, that we had a meeting last Friday and we're talking about the upcoming year. And I said, look, there's no better time to be a trial lawyer. The resources out there between what you're doing with Just Verdicts and, PAJ seminars, AAJ, and the internet has just been wonderful in terms of being able to look at so many resources to really up your game. And, let's be candid. This, what we're doing today started with a thank you phone call I made you a couple of weeks ago, just to thank you for doing the podcast, because between having Clancy Boylan on and Dom Guarini on his great verdict in Western PA. I used a lot of what came from those podcasts and some recent arbitrations that we had, and hopefully get a chance to talk about today. And, I think it's just wonderful. The fact that we as trial lawyers are able to pay it forward and give back and just share tools is, I think, what makes us very unique in the plaintiffs bar, and especially in Pennsylvania. You talk to colleagues from other states, and there's a lot more of a lone wolf mentality. But I think in Pennsylvania, between both coasts and getting together for our PAJ meetings or even some AAJ events, there's a lot of information sharing, and there's really not a whole lot of pride of authorship, which is great.
Yeah, I couldn't agree more with you. And first off, I want to thank you for calling me and paying me a compliment about the podcast, because a lot of times I feel like I'm just kind of talking out in the void, which is fine because I get so much out of talking with all of the guests. But it really meant a lot to me that you would take the time just to let me know that you're getting some value out of this. And but I could not agree with you more as far as it's almost like there's almost too much information out there these days. There's such a wealth of resources. I taught my first trial strategy class this past fall at Pitt. And as I'm sitting there with all these, maybe, young, soon to be lawyers, some of whom are definitely have interest in becoming trial lawyers, just trying to pare down what I would recommend them to focus on, whether it's, podcasts or the books or videos or seminars. It's really amazing how much out there. You have CVN, and I think back, and you don't look it, but you're a little bit older than me. And I can remember at the beginning of my career when I first started trying cases and getting my butt kicked, like there were not a lot of resources, even at that point in time. I remember David Ball on Damages first came out, and that was just, bowled me over compared to what I could find before that. Trial guides didn't even exist at that point. That book comes out, that blew me away and really set the course. And then Reptile, and then Trial Guides comes out, and I'm buying all these books. And then slowly over time, more and more and more information comes out there. And I think it's just super, it makes it really exciting because we're already doing this cool thing of representing people, helping people, the underdog story every single time. And now on top of that, you can constantly find ways to add, new things to improve. And it should never get dull is the way I look at it, because there's always something we can learn and apply and add to our practices that I think just makes it perpetually exciting and makes me happy to come to work. And, looking at different fact patterns, I'm thinking right off the bat, oh, well, maybe in this case I can apply this thing that I didn't get to do before and so forth. But yeah, I really agree. And continuing with, my intention of providing people more information to help them in their practices, you and I got to talking, and for me as a medical malpractice practitioner here in Pennsylvania, for whatever reason, I've been doing this for about 20 years now. I have never had somebody propose to me a binding arbitration in a medical malpractice case. I hear about them all the time. I'm very curious about them, but I've never undertaken one because it's just, for some reason, nobody ever offers that to me. And you and I were talking, and you recently had a couple very positive outcomes through that process. And, so I wanted to bring you on today, and I'm hoping that you will walk all of us who really haven't done the arbitration process before, or for those who have done maybe one or two and are looking to improve their chances the next time around, kind of a master class on, binding arbitration in Pennsylvania, specifically medical negligence cases, and I'd like you, if you could walk us through, very fundamentally, how do they come about? What are the types of cases that you see them sort of become an option that the defense is even thinking about? And when it first comes up, what's your thinking about, is this good for my client's case or not? What are the pros and cons of them? I guess that would be sort of the best, most simplistic way to start with this process.
Sure. So, it's relatively new for me as well. I've heard about binding arbs in med mal cases and really over the last few years, and then finally had an opportunity. So I had two cases, if we start there, and my apologies to those that are going to tune in and listen to this, but as part of agreeing to these binding arbitrations, I had to agree to some confidentiality provisions. So I've got to be a little purposely vague on names and verdict amounts and even defendants' names. The first case was a death case of a 23-year-old arising out of a small bowel obstruction that went untreated for far too long by a hospital facility in a neighboring county, Berks County. The second case, also from the same county, involved a misdiagnosis and delayed treatment of cauda equina syndrome, which is a very serious neurological disorder that happens in the lower back where the nerves branch out like the tail of a horse. It literally translates into horse's tail. And so those were the two cases. The second case, not a death case, but my client, who is now a young lady working, ironically, in the medical field after that experience, she's got permanent bladder incontinence, has to self-catheterize 4 times a day, and has a lot of associated issues, urinary tract infection. So those were the two cases. The first case, the bowel obstruction case, dates back to 2019. And, we named only the hospital on purpose because I didn't want to be saddled with 3 or 4 defense lawyers and, discovery taking 6 years, but it still took some time. The second case was even older, 2017, and in that case, I named a provider and the hospital, made a strategic decision to let the hospital out of the case and proceeded against the emergency department provider. And that case took forever because it just was such a hassle. We had to file motions to compel answers to written discovery, motions to compel depositions, and it just took so darn long. So the driving fact in both of those cases were there was no discussion of any arbitration. There were no settlement offers made. I had made what I thought to be reasonable demands given the venue, Brendan, but I just couldn't get any traction. So in both cases, we had a pretrial conference, and both of those cases were assigned to a particular judge, and that judge ended up retiring because he aged out. He hit age 75. So 2 cases that were taking, in my opinion, too long for how relatively straightforward they were. We finally get to the point of pretrial conferences, and now a new judge is assigned. And of course, that new judge is taking on a ton of work. And in both cases, 2 different judges, but they made clear that we weren't going to get to trial anytime soon. And it was at that time that we started talking to defense counsel. Look, do you want to try mediation? And they were a hard no on mediation. And um, really, the judge helped propose a binding arbitration in both of those cases. And I was a little skeptical at first, but we finally agreed to him. In the death case, I had concerns because my client, who was the decedent's father, he had some real medical issues that were causing me a lot of concern about how was he going to fare, how would he withstand trial process, especially if the trial spilled into 2025 or even possibly 2026. So that was a real driver. In the second case, the Equina case, it was just a factor of I knew we were going to get the trial anytime soon. And clients get litigation exhaustion, right? You tell them when you meet with them, look, this process can take 3, 4, 5 years on the short end and longer. And they hear you and they agree to that. But as the case comes around, all of a sudden, they tend to lose their zeal for it in certain cases. So there was a whole confluence of factors that led me to say, all right, let's consider this. So that's how we got to them. And then moving forward, the devil's always in the details in everything we do, right? Okay, well, who are the arbitrators? So there's the gamesmanship of, you propose some, they propose some, you try to propose some neutrals. And what I'm finding, Brendan, in this part of the state is there are a lot of lawyers who love to mediate cases. They want to be your mediator, but they're reluctant to be binding arbitrators in med mal cases. And I think that's a function of maybe they're worried about protecting a book of business going forward. Maybe they just don't feel comfortable saying, here is the decision, you have to live with it. But for whatever reason, the number of binding arbitrators seems to be shrinking. So in both cases, we had to go outside the area. In the death case, we found an arbitrator from Western Pennsylvania who's retired and splits time between the South and also comes back to PA. In the Equina case, we ended up getting an arbitrator from New Jersey who's a retired judge, and that's how that process went about. So, that's kind of how we got there. And then, there's a lot of, again, discussions about how is it going to work? Are we going to do full openings? Are we going to do full closings? Are we going to do a hybrid approach? What are we going to do with the experts? In the death case, the experts were presented by report with an opportunity to essentially say, at this time, my next witness would be, Dr. X, my radiology expert. Here's his report. Here are the important points. And then defense counsel gets an opportunity to say on cross-examination, here are the points that I would make. And we did that. In the second case, the Equina case, it was a hybrid approach. Some experts were introduced by report, and then some experts were called live, and it was the usual, direct examination, cross-examination. In both cases, our arbitrator, even though they heard closing argument, wanted written submissions, I think, just to, kind of gel everything together. So that's a little bit of an overview on how we got to where we went to. But again, venue is an important consideration because let's face it, not all of us have the ability to try cases in great venues like Lackawanna County or even Philadelphia County, although we know that a med mal case is a tough case no matter what the venue is, right? Who is your trial judge is a consideration, and what is that judge saying about scheduling? Are you going to have a date certain or are you not? In both of my cases, that proved to be one of the main factors. What are your client's desires and circumstances? That has to be taken into consideration. It's easier for us to say, hang in there for another year, but doesn't always work with clients, especially in the former case, the death case, where I had some real concerns about my client's emotional well-being and stability, having to wait a whole other year. And then you have to look at, do you have expert issues? Which candidly I had in the death case. And, the experts were on board, they knew the venue, but all of a sudden, as we started getting closer to the pretrial conference, they're putting up red flags. Well, gee, I don't know if I can be there. And then we had a judge that says, look, they're either on video or they're coming live, but we're not doing live by Zoom. And, it's that was an interesting dynamic I had to work through.
So one point and a couple questions for you. So one, to the observation you made that you have found a lot of mediators are hesitant to serve as arbitrators because whether it's a conflict, whether it's a fear of impacting their book of business, I have heard through the grapevine of such a situation where, pretty well-known mediator served as an arbitrator, entered a, what they believed was a very fair verdict in favor of the plaintiff, and the hospital system who had agreed to this person as a mediator in many of their cases from then on was very displeased, and from then on said, we are no longer using that person not only just as an arbitrator but as a mediator ever, and it has remained that way as far as I can tell. When I have proposed that person in cases with this hospital group in the past. So I think that's a real concern for people, and why you probably do have to go out or find just the right type of person. One question, though, is in both of those cases, you talked about the unique circumstances of, retiring judge, cases languishing, new judge comes on, overwhelmed. Did that judge sort of forcefully suggest to everybody, hey, you should arbitrate this? Or was it just, they agree and by chance the defense, went along with it? And two, what, from your vantage point, what are the reasons why a defendant doctor or hospital would be interested and agree to an arbitration?
So taking those one at a time, in case number one, the death case, the judge absolutely positively was very heavy-handed about getting this to binding arbitration. There was no doubt about it, right? In case number two, the judge wasn't as adamant, but made a suggestion, and then it just kind of worked out. It just happened to work that way. In terms of why would the defense agree, again, they're looking at the same issues we have, right? They may have doctors that want to get the case resolved. They may have hospital networks that want to get the case resolved. They're looking at it from what is our exposure, on the venue. They may too have expert issues as well. So I think, the sun, moon, and stars have to line up as to why they would agree. And really, one of the things, the benefits, and I had to really weigh this heavily before I agreed, was in both of my cases, I had confidentiality provisions. And so for the individual doctor in case number two, the lack of publicity, the lack of the verdict getting out, and really for the hospital network in case number one, it was the same thing. So that was sort of one of their driving forces. We will agree to this if you agree to confidentiality. And I know there's a lot of our colleagues that say under no circumstances ever will I agree to confidentiality for a settlement amount, a mediation result, or anything else. But I think you got to look at the big picture, and it just happened to work for me. I will say, going back to the initial point of mediators and arbitrators, quote unquote, being taken off the list based on the awards they give or the results, a lot of that works both ways, right? I mean, I've heard of colleagues of ours on the plaintiff side that say, well, I got zeroed out in this case. It was a defense verdict, so I'll never use him again as an arbitrator. And look, I've had the experience. I've had 3 med mal arbitrations now, 2 this past summer that worked out very well, and one that didn't work out so well that I thought was a really strong carpal tunnel case. And I got a defense verdict, and I thought it was a strong case. But, I wasn't about to say that the mediator's off the list. Ironically, the arbitrator. Ironically, I used the same arbitrator. I went back and I thought that he was engaged and knowledgeable about the submissions and paid attention. So, look, any one of us doing this line of work knows that a defense verdict is a distinct possibility in every medical malpractice that we take to trial. And if that's the case, we have to understand that a defense verdict is a real possibility in any medical malpractice case we take to a binding arbitration. So I've taken kind of a bigger view of the world and understand that there's pros and cons. But this whole business that I'll never use them again because I get a defense verdict, I think is a short-sighted view of the world, especially because on the East, and you're hearing it in the West, the number of arbitrators willing to do med mal cases isn't that great a list to begin with. So, and to a point, it's one thing to say I'm going next door to New Jersey or I'm going to the western part of the state, or for you, the eastern part of the state. But I don't know that I have the comfort level to get a binding arbitrator who is from West Virginia or, South Carolina. I'm not going to go that far because there are nuances relative to Pennsylvania law that I just don't think an arbitrator from out of state, very far out of state, can get their arms around.
So to the point that, you're 2 for 3 on your ARBs, and this, I'll tee this up with a seminar that Shane Inspector gave many years ago. I didn't attend it, but somebody provided me the materials, and it was really interesting. The gist of it was sort of counterintuitive advice of trial work. And one of the points, and I think most people would be surprised by this, but he made was, as the plaintiff, if you're going to trial and you are given the opportunity to try your case to a jury versus try it to a judge as a bench trial, that in many instances, the bench trial is the better option for our cases than is going before a jury. And my takeaway, I think it's probably more nuanced than what my takeaway was. But I mean, one may be the arbitrator or the judge on average is maybe more sophisticated than a jury and but that could cut both ways. But the other big takeaway is that the individual decision maker, a judge, an arbitrator, is more likely to, quote, split the baby on average than a jury may be. Meaning, you have, as a plaintiff, a better chance of getting a recovery in arbitration than you would on average before a jury in a med mal case. And I'm curious what your feeling is about that.
So I think I attended that CLE that Shannon gave. And along with that, he had a couple other really salient points. But as a general rule, I'd agree that I think the chances are better if you can get your case to arbitration. Now, having said that, you have to understand, as Shannon points out, and you just referenced, an arbitrator may be more inclined to quote unquote split the baby, but understands the nuances, right? Any one of us that have been doing this for any length of time, that have talked to jurors afterwards in cases that we've won and cases that we've lost, understand that juries make decisions based on the craziest things. Not necessarily the medicine, not necessarily, the credibility of witnesses all the time. So I'd agree. And I think, Brendan, that's one of the reasons why there's such a reluctance on the defense side to go to binding arbitration, right? We don't see a whole lot of it. And I think there's a fear from the defense side, well, an arbitrator is going to give them something, and I like my chances in making them convince 10 out of 12 jurors, so we're not going to agree to any binding arbitrations. I think that's why it's just such a rarity. Having said that, again, as I said, the devil is in the details, right? It has to be the right case. It has to have the right set of facts. You have to have a candid assessment about what are the problems I'm going to have if I go to trial, and is an arbitrator going to be more likely to understand the nuances of my problems versus a jury that may have no sympathy towards it. But look, give me an opportunity. I still try a lot of criminal cases, okay? And I just finished about a month and a half ago, a very small auto case. So I'm trying all different kinds of things. I do construction litigation. I've had some construction trials, and when I have the burden of proof, the less people I have to convince, the happier I am and the easier my job becomes. You get into federal court, you're not necessarily having to deal with 12 jurors, but you still have that dynamics of 2/3. So I think Shannon is spot on, and I would just encourage more of our colleagues to not rule out arbitration. For me, look, I've done this long enough, and I've been knocked around long enough and lost enough cases where I don't need to have any ego in this. For me, it's about what's the best path for my client. And what's the best thing for them, big picture.
Yeah, I've gotten to that point as well. The more cowboy nature of, let's try everything, try as many cases as possible. I mean, obviously, I still love to try cases, but yeah, much more, I think, thoughtful as what is the best option for the client under these circumstances. Can you drill a little deeper into how these actual arbitrations were carried out? So, for example, did you go to a unified location where everybody showed up, or did you do it by Zoom? And what were aspects of the was it a one-day arbitration? Was it multi-day? Was it as far as scheduling and planning, which oftentimes I find to be the biggest headache when you go to trial, was that easier on your overall process as compared to a full-blown jury trial?
Sure. So case number one, the death case, the bowel obstruction case, entirely in person. We went to defense counsel's office outside of the Philadelphia area, and we did everything there. The arbitrator appeared live, and that case ended up taking 4 days to arbitrate. Initially, we were talking about doing it by Zoom because we thought it was going to be the better part of 2 weeks. And then as we got closer to hammering out details, we had some agreement on certain reports being presented in lieu of live testimony, and we were able to narrow it down. The beauty of it is compared to a jury trial, I mean, this would have been a 2.5-week jury trial at least, right? We started early in the morning, shortly after 9 o'clock. We went a good portion of the time. We had a little bit of a hiccup with a defense witness who got stuck in some bad weather and flights were missed and everything else. So that really added another half day to the process. But we were able to get it done inside of 1 week, and it was live. Case number 2, at the judge's insistence, everything was by Zoom. So my clients came to my office, defense counsel, and his client. His client was actually by Zoom, defense counsel in his office, and that case was much shorter. That was a 2-day case. That probably could have been a 4-day trial, and we were able to narrow it down.
Which did you prefer, the in-person over 4 days or the Zoom?
No, listen, I prefer in person. I am not a big fan of Zoom depositions. If you want to depose my client or my witnesses by Zoom, be my guest. But if I'm asking the questions, I just think there's something to be said for being in the room. There's just certain things that you pick up on. I think it's a lot more effective. Having stumbled for the first part of my career, like many young lawyers, I think I've gotten to a point now where I can have a pretty good read on witnesses and can do an okay job controlling, the narrative and controlling the room. So I prefer to be live. And also, let me add this. For the clients who have been waiting years and years and years in these cases, right, they all do, I think it just gives them a little bit more sense that they're getting their day in court, even though it's an arbitration, if they're with live people and the judge is there. I think it adds an element of seriousness. It makes the client feel better regardless of the outcome. It makes it feel more like the real thing in person. The Zoom I wasn't crazy about, but it was the judge's insistence. My clients were fine. We had a great result for her in the end. But I just felt like, geez, am I really giving this client a full cup of justice by doing this by Zoom? And we talked about it at length, and they were on board. And honestly, if they would have insisted on in person, and they would have been to the point where I thought they were uncomfortably not happy about Zoom, I probably would have just said, well, then we're not going to do it. Well, let's look for another arbitrator.
In the in-person 4-day ARB, did you have your client, I mean, were they there, all day, every day? And same on the defense side, did they have somebody present throughout the arbitration process?
So for me, in the first case, the death case, my client, the father, was there for the entirety of the arbitration. Now, there were portions where I had him leave the room, particularly when some family members were testifying, because I just thought it was going to be too emotional for him. And I wanted to be conscious and considerate of his feelings. Because look, for us, right, we finished the case and, hopefully get a good result. And we're moving on to the next case. But I think, in very emotionally charged cases, you've got to be sensitive to the fact that your client is not only living with the result, but also living with what they saw and heard from certain witnesses, especially close family members. So he was there in the building, but not necessarily in the room for the entirety. In case number 2, my client was there for the entirety, and it was the same thing. When her parents testified, I asked her to step outside for 2 reasons. Number 1, I didn't want to have her traumatized about seeing how her parents recounted what she went through. And number 2, quite frankly, it made for better testimony from mom and dad because they were able to speak a lot more freely and they let their guard down, which was good for me. So, to recap, Brendan, both cases, they were there, but at certain points, I asked them to step outside.
In your estimation, comparing, you've tried tons of jury trials and obviously much more formal and in a different audience that you're speaking to. The arbitrator almost always is a former attorney or current attorney who now has developed a practice as a mediator and arbitrator, whereas in trial it's 12 or 8 citizens from the community. As far as your presentation in arbitration, I mean, what I find every time I have like preconceived notions about what I'm going into. Then I go into it and I'm like, oh, next time, I'm not going to do this. I'm not going to do this. I'm going to make this more streamlined. Comparatively between a jury trial, how does the arbitration how does your approach to arbitration change as far as like, are you much more truncated because you know this arbitrator has probably read a lot of the materials ahead of time and is just generally more savvy so you can kind of cut to the chase? Or are you still doing and think there's any value to, full-blown opening, full-blown closing, that kind of thing?
My approach to arbitration is to prepare it the same way as if I was going into a jury trial. So, there are no short steps, shortcuts, anything else. I still, in both arbitration cases, prepared as if I was going to give a full opening argument because it just helps me with the overall presentation, right? It allows me to make sure, hey, does this make sense? Am I sequencing this correctly? Same thing with witness outlines. I'm just not good enough to wing it with one sheet of paper with a couple of bullet points. I still have outlines. I never write out every question, but I still go through the outline because it helps me prepare. Same thing with closing arguments, right? I want to give them in the arbitration for a couple of reasons. Number one, I want the arbitrator to get it while it's still fresh in his or her mind, even though they've had experience, they've been on the bench, whatever their background may be. But number two, I think it's important for the clients, right? Like they're trusting me to go with this arbitration idea, but they're still entitled to their day in court. And I think that just helps the process. I'm formal to the point where every day at arbitration, I'm wearing the same clothing that I would for trial. And I still take the David Ball approach and that others have taken. I think Mike George from your part of the state about, not going in there with a fancy watch and, a really, really expensive Italian custom suit, things like that. But, I still take my music stand, which is where I will question my witnesses from. I don't want to be loosey-goosey and just sit there and, wing it from the conference room table and just spin my chair around. So there's a lot of formality in how I address the arbitrator, in how I move exhibits into evidence, and how I make objections. I want to try to keep it as jury trial-like as possible. Having said that, sure, there are things that are truncated, right? If we have an agreement that some or all the experts are going in by reports, it makes it easier. But where I am really, really comprehensive, I feel, is in my pre-arbitration statement. I will, even on cases that are submitted by reports, I'm not just going to attach the report and say, here's Dr. X's report attached as Exhibit A. I'm going to say in one or two sentences, here are his qualifications, his CV is Exhibit A. Here are the points that I would make, and I will quote from the report so it's right there. So the arbitrator has it right in front of himself. I don't want to make the arbitrator flip to Exhibit A and where is Exhibit D and all that. So, I try to keep it as formal as I possibly can.
Did you find defense counsel did the same thing, approached it with the same level of, it sounds like you're getting up and standing and giving an opening statement. You're going to, some small podium or something to maybe question witnesses. Is the defense doing that, or were they more lax about it, or was that agreed upon?
No, it was agreed upon. They were fairly formal in their presentations. We ended up dispensing with formal openings in both cases, so I just want to make that clear. But my process of preparing the opening, I was in my trial binder. It was tab 3, which is usually where it is, just in case the arbitrator changed his mind or her mind, as the cases were, and said, "Look, tell me a little bit more about the case." So I was ready to go. But we dispensed. But the closing arguments were formal, both following testimony and then even in post-hearing submissions.
So in closing, you're getting up and, all the evidence is in, and you're now giving, a focus to the arbitrator closing, not unlike you would do with a jury.
Right. Yeah. Now, in some responses, it's a little more truncated. I'm still a David Ball disciple, right, from damages in terms of debunking. And then, in closing, when you retire to deliberate, you have 3 important jobs. Let me tell you what they are, and this is how you can go about them. Obviously, you're not going to do that with an arbitrator. So the closings can be a little bit more truncated, but I'll cover the jury instructions, preponderance of the evidence, more right than wrong, factual cause, something real or actual that made something else happen, whatever the case may be. I'm not dispensing with that because at the end of the day, the arbitrator is supposed to make a decision and apply the law. So I don't want to take it for granted, especially in case number 2, the Equina case, where the arbitrator was a New Jersey retired judge. There's some nuances and differences in the law between our neighbors in New Jersey and what we do in Pennsylvania.
Did you give a closing or resume in the second case?
Yes, as well as post-hearing post-arbitration submissions.
And how did that compare to, the traditional getting up, person's there, you're walking around and speaking to them?
I handled it the same way. I stood, music stand were an idea I took from Shannon, by the way, with my notes in front of me, may it please the court, and recognize defense counsel and recognize my client, and then proceed. So I don't wing it. I just think if you're going to do the arbitration, do it the right way, and do it the way you would as if you were in a courtroom with a jury.
Technically, in a Zoom arbitration, did you undertake any, specific kind of tech steps ahead of time such that your camera is able to show you properly position of the room, at the music stand, giving a closing just like you would in trial? Or, is it, hey, I've got my my camera on top of my computer, I'm just going to make sure I'm in the video, that kind of thing?
Well, in the second case, when we did it by Zoom, we have what I call the Zoom conference room with a better camera. I'm not just doing what I'm doing here with the laptop camera. I had a trial presentation business partner for both cases. We agreed to with defense counsel who it would be and shared in the cost. But no, I had somebody else present it. The exhibits for the second arbitration, we called up on the screen. We used a telestrator to highlight them just as we would in front of a jury and pointed it out that way. So, we tried to make it as real as possible, understanding we were by Zoom. I did not go to the length of having multiple cameras. I just didn't. I didn't do it, and maybe in hindsight, I should have done it. Would probably think about it for the next Zoom arbitration if I'm fortunate enough to do it again.
What's the conversation like with the client about what, okay, we have this opportunity to do this as an arbitration rather than a jury trial? Because in their mind, they're probably apprehensive, but they've seen on TV most frequently jury trials, so they have some sense of that. And now you're telling them, well, there's this different way that we can have this case adjudicated. What's that conversation? And, how do you sort of explain, and do you leave it up to them as far as, we can do a jury trial, it's going to take longer, or you can do this arbitration, just go with the pros and cons and leave it up to them to decide? Or are you making a recommendation, hey, I think this is really the better way for your case?
Yeah, in both cases, we had a very open conversation with both clients. And look, here are the pros, here are the cons. For the first case, my client was present for the pretrial/settlement conference with the judge that strongly recommended the arbitration. He didn't go back into the judge's chambers to participate in those conversations, but he was in the courtroom. So very intelligent, articulate client. He understood, and we just weighed the pros and cons, and I got his blessing to go ahead and proceed with the arbitration. It's a tough decision. Look, it's no tougher a decision than what clients do we call in a jury trial? Do we put this witness on? Do we not call this witness? Right? It's a lot of responsibility to take onto your shoulders to make this recommendation. In the second case, it's the same thing. We had an open conversation. We talked about the pros and cons. I always, tell the clients, look, we're not going to decide this instant. Think about it. And then we got back to the judge in both cases after we worked out details with defense counsel and said, we'll go the arbitration route. In terms of the clients for the arbitration, it's a little easier because you don't have that angst of worrying about where are the clients going for lunch? How are they behaving during the recesses and the breaks? What do they look like walking into the parking lot? That gets truncated, and you're not worried about giving those lectures. But in both instances, I had the clients came to my office. I showed them the technology. I showed them where they'd be sitting. I explained where the microphones are. So they understood the lay of the land. So they just weren't walking in, for the first time when it was their time to start their direct examination.
In your case in chief, and either if they were, well, obviously they were different because one was Zoom, but let's stick with the in-person ARB. Did you call any live expert witnesses, or was everything done by reports?
No, the second case we had live experts. The first case, they were submitted by reports.
And is that because the first case was in person, it would have been more difficult and expensive to get the experts to come in versus the other one Zoom, and you could just Zoom your experts in?
First case, the death case, we just came to an agreement, defense counsel and I, and there were some concerns I had in terms of logistics and the experts live. Plus, I didn't know when that trial date would be actually rescheduled too. And I felt confident and comfortable in their reports. Now, there are some issues that we can circle back to in a little bit that came up during the arbitration with the experts that, we had to make some quick decisions on the fly about. The second case, there was a combination of experts by reports and experts live. And, it just worked out that way. Well, learn treatises, right? We found in the first case, the bowel obstruction case, my main expert had written a report that, at least on its face, to defense counsel, thought it was an aha moment because it appeared inconsistent. And I was just given that literally the day before that expert was going to be formally called and presented by way of report. And fortunately, I tried that case with my partner, Eric Prock, and Eric just did a yeoman's job. He was phenomenal in just looking at the research and looking at the articles, including one cited by defense counsel. And we ended up finding some nuggets as we dug deeper. But he was able to take a look at the report in relatively short time, jump on his iPad and even call the expert. And we were able to reconcile what on its face appeared to be an inconsistency, but wasn't. So those issues come up and you have to be ready for them no matter what. Which brings me to another point too, and again, I'm on the Middle District mediation panel. I've had a chance to mediate successfully a lot of med mal cases as well. And I think one of the things that all of our colleagues need to be more cognizant about in med mal cases is there's a lot of gold in them, their hills, in terms of learned treatises. And if you dig deeper, even looking at some of the publications from the defense experts, there's a lot of good information we can find. In the bowel obstruction case, we were able to find that the chief liability defense expert had actually given some deposition testimony that I was able to find through some of our PAJ colleagues, and written some reports that were just completely inconsistent. And it's stuff that I think, had counsel done a little bit of homework, that they might have seen that up front. And who knows if it would have changed the settlement posture, or it was too far gone at that point. But I think the med mal cases, more so than a lot of other cases, you really have to do the digging. And it works both ways, right? Because, let's face it, we've got experts that we call as plaintiffs that are well-traveled, that have been doing this a long time. So it's not just enough to dig for the dirt on the defense experts. You've got to know what your own expert has out there as well.
Can you expound a little bit on that issue that arose in the first case? So you're presenting your experts on reports, and the defense brings to your attention a learned treatise the day before you're essentially going to offer that report that, at least ostensibly, looks like it could undermine their opinion, right?
Yeah, it wasn't even a learned treatise. It was a little bit worse than that for me. It ended up being a narrative report that my expert wrote for a defense lawyer who practices both in Central PA and out west. And they were going to use that to basically make the argument that, hey, this expert's taken inconsistent positions. And it had to do with one of the findings on a CT scan. And in my case, the expert said that, look, this finding on the CT scan is highly suggestive of a surgical emergency, and the delay in getting the patient to surgery proved to be fatal, essentially. In the report that defense counsel was going to spring, that same expert, for a defense lawyer in defense of a med mal case, said that same finding on the CT scan, pneumatosis intestinalis, air in the walls of the small intestine, was not a surgical emergency. And defense counsel figured, okay, that's the aha moment, because the expert's waffling on that finding. But as we poured through that expert report, there were reasons why we were able to distinguish why it was a surgical emergency in our case, but wasn't necessarily a surgical emergency in the other case. And we were able to reconcile it pretty quickly.
Did you have an agreement with defense counsel that impeachment materials would be produced in a timely fashion? Or because it's in my trials, my defense counsel is not giving me their impeachment testimony or materials the day before my witness goes on.
Yes and no. We had the agreement. So the agreement was, we're going to put it all into the pre-hearing submission. So I had, my section on who my witnesses were. I had a separate section on, these are my experts, these are their qualifications, these are the key points, right? So I'm condensing sometimes a 10-page report down to 2 pages worth of bullet point conclusions and opinions my expert has. I also put a section in about the defense expert and said, look, here are the points, Mr. Arbitrator, that you need to remember when you hear from this defense expert. So I kind of put my chips to the middle of the table and figured, all right, I'm going to put it all out there because you're going to hear it anyway, and I'll do it in summation. For the most part, I'll say, since I'm not going to mention names, defense counsel was true to that agreement, that did the same in their memo. But, this report was one thing that kind of came out. And there were some things that I found that depending on how the defense was going to present their report and their summary of the report, I was going to then attack it, and I did that. So there was a little bit of gamesmanship on both sides with impeachment materials, but for the most part, I was pretty transparent about where I was going and what I was going to do.
In these two ARBs, the bowel obstruction and the cauda equina, any other noteworthy aspects of the process or the cases that you think would be important for people, considering going into their first arbitration to be mindful of?
Yeah, I think, it boils down to just having a realistic understanding of your venue and doing your homework. I'm fortunate enough to have a satellite office in the county where both of these cases we've been talking about are venued. And, I've got an attorney that's got as much experience as I do in that county. So I was able to get a real honest to goodness sense of where has that county been on med mal cases? What do the verdicts look like on those few where there has been a plaintiff's verdict? What's the background on the judges? Are they really going to give me this trial date certain that I have, or is it going to get pushed? And then we had the retirement issue. So I think venue is a big one. And then really, I did a lot of informal focus groups on my case and had a sense of what did people really think. And, in my focus groups, as yours and others of our colleagues, I'm interested in the bad. I don't need a focus group to tell me, hey, you got a great case and we're going to award you $10 million, right? Because as we know, statistically speaking, the opposite result is more likely to happen. So, and doing those, I knew that there were things that I had to really think about, especially in the cauda equina case. There was a strong defense argument in that case about comparative, that, okay, you went in on Friday, you were discharged, and then on Sunday, there was an episode where she lost all bladder function, peed herself, and, had discharge instructions that said, if there is a change in your condition, contact your family physician, return to this hospital, or seek medical attention. She has the incident Sunday mid-afternoon and waits until Monday morning to follow up with the family doc who wasn't in, and then the chiropractor, and then there was a same-day stat MRI ordered. So there were some issues there that I had to look at. So the best advice I can give is keep an open mind if the opportunity presents itself for the reasons that Shannon has talked about and that we've discussed today. Know your venue, know your judge, and have a real assessment of where are the warts in your case, where are you going to be attacked, and then I really had expert issues that I had to really weigh in and think about and kind of work around. And then finally, it's where is the client and how is the client going to present, right? I mean, it's not every case where you have the all-star client that's going to hold up great under cross-examination and is resilient enough that if the case is going to get pushed another year, they're going to want to stick in there with you. So, you got to look at the big picture is the best advice I can give. And then, there's always going to be the jockeying on who is the arbitrator going to be, because I just find that the pool of available arbitrators that are willing to hear these cases is starting to shrink.
And starting to wrap up here, but still just a few kind of procedural questions. And you started this interview by talking about the devil's in the details. Can you speak a little bit more about, the extent of the agreements on how you were going to arbitrate? Like how written out were it? What was it? What were the rules? And also, how, and this kind of ties it up, but practically, how does a verdict for or against your client in an arbitration work? So let's start first, at the beginning. How detailed are you getting regarding how this is going to be done? And here are the rules that, both sides are agreeing to follow.
Very detailed. Once we had an agreement in principle to arbitrate, then we decided on who was going to be the arbitrator. And after that, in both cases, it was probably the first case, I think it might have been a 7 or 8 page long double-spaced arbitration agreement that covered everything from pre-arbitration submissions, the prohibition on unilateral contact with the arbitrator, ex parte contact with the arbitrator, what the openings would consist of and what time limits would be placed if the arbitrator wanted a formal opening, the witness list, so we were able to prepare. We didn't necessarily get into the sequencing of witnesses, but we talked about experts and the fact that there was a full disclosure of the most updated CV and all reports, so there were no surprise reports that were going to come up, that the reports would be submitted in lieu of live expert testimony in case number one and case number two, which experts would testify live, and that had to be amended as we got closer to the ARB date. Brendan, we talked about even the use of learned treatises, and in the first agreement that they could not be used to bolster consistent with the evidentiary rules. We talked about closings. We talked about page limits and contents of a post-hearing submission if the arbitrator wanted one. And then in both instances, we agreed on a proposed verdict slip, and that was the verdict slip that was given to the arbitrator. So it was really buttoned up from start to finish. Again, stuff always comes up. Witness unavailability, the arbitrator makes all evidentiary decisions. We had argument. There were some motions in limine that had been filed as part of the regular trial process as we got closer. And we worked out those motions in limine. And in case number one, we presented them to the arbitrator and had rulings just as we would from a trial judge. So, I would, especially in a med mal case, caution against going into this without a very tight arbitration agreement. It protects you and it protects, the other side and also helps the arbitrator along.
And I imagine it has to be signed off on, right? Both sides are agreeable. And sort of akin to the form releases we'll get when we settle our med mal cases. Did the defense have sort of a starting form that then was, sent back and forth and hammered out the specific details of your case, or did you guys create it from scratch?
In case number one, the death case, I took the lead and basically, just dictated it and then sent it over, and there was a lot of back and forth. In case number two, defense counsel had, quote unquote, their form, and we tweaked it. Also, to be clear, in both, there were confidentiality provisions that, some of the provisions I pushed back on, but, that was it was kind of a cost of doing business. If we were going to do the ARBs, that was non-negotiable from the defense side. And it's something that I also talked to my clients about before I signed it on their behalf, and we were set to go.
So let's wrap up by talking, how does it conclude? So you get a favorable ruling. What happens? I mean, what is the effect of it? And technically, what happens next when the arbitrator finds in your client's favor?
Right. Well, we got the award. And fortunately, in both cases, the defense honored the agreement as we had it laid out. And, the checks were timely issued. There, in case number one, there was no M-Care involvement, so that made it a little easier, which is always, I don't know of any M-Care cases where they've agreed to binding ARBs. Maybe one of our colleagues has one out there and they can get in touch with either you and me to talk about. And in case number two, it was the same thing. They paid the award in a timely fashion and, we were able to get them resolved.
Is there a separate agreement that has to be entered into, or is that already taken care of by the pre-ARB agreement?
No, it was taken care of in the pre-ARB agreement. So it fortunately, knock on wood, everything went very smoothly and the case is resolved. And the same thing happened in the first case that I had where, we ended up getting a defense verdict and it was pretty straightforward. The case concludes, you file the official precipice to settle, discontinue, and end with prejudice once you get the result, and, we moved ahead.
And then lastly, if you get a finding against an individual doctor, does it count as, for example, like a mark against their, national practitioner database, like a settlement or a verdict at trial would?
In the second case we had, where I released the hospital, the entity defendant, and proceeded only against the provider, they did have language in there that they felt that it would not count. And my view was, look, your reporting requirements are your reporting requirements. You handle that however you want. So I made sure there was language in there that I wasn't responsible to do anything. From my perspective, I wanted to know what the arbitrator's decision was. Hopefully it would be favorable, which it was. And then it was just a matter of getting the check and then, making my disbursements. And I did have liens in both cases that I had to resolve. I've left that to defense counsel and the individual doc, and what they've done with that, I couldn't tell you.
Awesome. Well, Sud, I think that's a good stopping point. This has been great. Sud, thank you very much. Sud Patel, Fanelli, Evans, and Patel. Sud, what's the best way for people to get a hold of you if they want to talk to you, pick your brain, refer you a case?
Sure. Patel at feplawyers.com, or just go to our website. My contact information is there. I'm usually at a lot of the PAJ events to track me down. But Brendan, again, I can't thank you enough for giving me the chance to come on. What you're doing is a great thing. It's must-see TV, even though it's a podcast for anyone doing this line of work, med mal or otherwise. I can't thank you enough. And I would be remiss if I didn't say, go Eagles.
Go Eagles is right. I'm rooting for you guys as well. So thanks again, man. Look forward to seeing you in person one of these days. And thanks for doing the pod. And again, great timing with this alarm going off here.
All right. Thanks again.
See you soon, man.
Talk to you soon.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.